Hello and welcome. You're watching Newscenter. I'm Parikshit Luthra. The Supreme Court has pulled up the government after it submitted the one rank, one pension payment roadmap in a sealed cover. Chief Justice D.Y. Chandrachud said that sealed covers are fundamentally against the judicial process, adding that the sealed cover procedure needs to end. Otherwise, high courts will also start following the practice. Recently, while hearing the Adani Hindenburg matter, CJI Chandrachud had refused to accept the sealed cover by the centre, which proposed names for the expert committee. Joining me now to take this forward is Justice Madan B. Lokur, former judge of the Supreme Court. Justice Lokur, thank you very much for joining us. Give us a sense of how this practice of submitting reports in a sealed cover before the court affects transparency and the administration of justice.
Yes, thank you for inviting me. You see, the court system that we have in India is an open court system. It is transparent. Anybody can walk into the courtroom and watch the proceedings. Of course, there are certain exceptions, when some proceedings are to be held in camera. For example, in matrimonial disputes or matters relating to sexual offences and so on. But by and large, constitutional issues, they have to be held in an open court. So really the practice of a sealed cover is the antithesis of having an open court. There are exceptions to this in the sense that Section 123 and Section 124 of the Evidence Act provides for the state, that is the government, producing documents only for the consideration of the court. These are called privileged documents. Now, such documents have to be produced, they can be produced in a sealed cover, along with an affidavit of the head of the department concerned. So, if it's from the Government of India, for example, a particular ministry, then the secretary of that ministry has to give an affidavit giving the reasons why the documents are privileged and why they should not be disclosed to the public. The court will then decide whether in fact the documents are privileged or not, and if they are not privileged, then the court will unseal the documents and make it available to the public for scrutiny. There have been instances of this nature in the past where some documents have been given, and the court has said, well, we don't think these are privileged documents. You see, privileged documents are those which pertain to the affairs of state, right? Something like foreign relations, for example. What is the relationship of India with some other country? These are matters which are affairs of state, and for which, of course, the court will not, usually reveal these documents to the public. But the present system
Justice
of,
Lokur,
putting any and every document, yes, please. Yes,
Justice Lokur, do you feel that the practice of sealed cover jurisprudence has been exploited over the years by the government?
Yes, in the sense that, now any and every document is sought to be placed in a sealed cover and handed over to the court without complying with the provisions of Section 123 and 124 of the Evidence Act. So the court should definitely discourage this. They can take documents in a sealed cover, but then they must be accompanied by the affidavit of the secretary of the concerned ministry. That is not happening. That is where the problem lies.
Considering, Justice Lokur, that this practice has been happening, very recently we had seen it in the Adani Hindenburg matter, where the court came down very strongly on the government counsel, stating you cannot be giving your recommendations on how the committee should be formed. The people who should be a part of this committee, you cannot be giving this in a sealed cover. It's a matter of national importance. Everyone should know about it. But how do you think the Supreme Court can really clear the air as far as the sealed covers go? Because as you have said, it's become a commonplace practice. It's happening in high courts. It's happening in Supreme Court.
Well, the only thing is that the Supreme Court should insist on an affidavit in accordance with Section 123 and 124 of the Evidence Act. from the head of the department, that is the secretary of the ministry concerned. Right? So it has to be by some responsible person. It's not that, somebody just hands over a sealed cover to the government lawyer and the government lawyer then hands it over to the court. There must be an affidavit of the concerned secretary of the ministry. That is the law.
Right. Justice Lokur, do you also believe that somewhere over the years the Supreme Court has also made this mistake of overlooking the procedure when it comes to the sealed cover jurisprudence?
Yes, it has. It has. You see, I don't know the reason why it has overlooked this procedure, but by and large, in a case, it's very, very unlikely that some document pertaining to the affairs of state will be produced. Right? It's very unlikely. So I think perhaps taking advantage of this, the sealed cover procedure, got initiated. But yes, I think, because it has now become routine, there must be an insistence on an affidavit. Otherwise, this thing can just go on and on and on, without stopping.
So we've been reading about sealed cover jurisdiction, and earlier it used to pertain to administrative matters, matters relating to promotions or career records of bureaucrats, government officials, affairs of the state. If we were to ask you about the origins, originally the kind of cases where the Supreme Court insisted on an affidavit, why this should be, or a particular matter should be submitted to the court in a sealed cover, could you give us the origin and the kind of cases that were initially handled by the Supreme Court?
Well, let me go back to the judgment delivered by the Supreme Court in the case of S.P. Gupta, which related to the appointment of judges or the permanent appointment of judges, or judges who were additional judges and were to be made permanent. Now, the government, produced the files, and they said that we are claiming privilege. So the Supreme Court went into the arguments of privilege and said that these do not pertain to affairs of state. All right. So they said that the lawyers can have a look at it and make their submissions on the basis of the files that you have produced. There is only one limitation, and that limitation is that the documents on which privilege is claimed and which is declined by the Supreme Court cannot be used, in other proceedings, right? So in S.P. Gupta's case, they said there's no question of any affairs of state in this, and whatever was there in the files was made available to the court and to the lawyers. There have been several such cases in the past, where, say, there's a file noting, somebody higher up disagrees, then somebody further higher up, has a different opinion. And they have said, oh, you see, these are matters of state and they should not be disclosed. But the Supreme Court has never accepted this kind of thing. I can't offhand say of any case where, privilege has been upheld. But I would say that, issues of foreign relations, for example, cases which clearly fall under 123 and 124 of the Evidence Act would be affairs of state, not, just any kind of document that the government wants to produce.
Right. Any case which you recall, Justice Lokur, where the administration of justice was impacted because of the submission of government's views or arguments or status on a particular matter in a sealed cover?
I can't offhand recall any such case, but something like investigations, for example, the status of investigations or a status report on investigations, these the Supreme Court or any court for that matter, will not disclose, because that can impact the investigations, right? So there, I suppose, the court is a little more liberal in that sense, and permits sealed cover. But then that is because it is in the interest of the parties, that is the prosecution as well as the accused, not to disclose the status of the investigation. But in constitutional matters, I can't recall any such instance, where documents have been given in a sealed cover and not disclosed to anybody.
Okay. My final question, sir, considering that there may be so many precedents of governments giving their status reports, recommendations in a sealed cover to High Courts and Supreme Court now, will it be difficult for the Supreme Court now to insist in future cases? Do you think there'll have to be a very clear word by the Supreme Court from the Chief Justice's bench on this?
It's not necessary because the law is already there, Now, you mentioned recommendations. Now, recommendations do not pertain to affairs of state, except, I suppose, when you're wanting to post somebody as an ambassador to a different country, or when India has an objection to somebody being posted as an ambassador to India of some foreign country. So, I mean, these kind of recommendations are, hardly anybody ever, I don't know of anybody having challenged these kind of recommendations. But recommendations of another kind, they can't be privileged documents. You could have,
Right.
The Supreme Court calling for a report. For example, the Supreme Court has called for a report on the Pegasus issue. Right? The Supreme Court called for a report on a fake encounter. Okay. Now that is entirely for the Supreme Court to decide whether, because it's a report that the Supreme Court has called for. So it is for the Supreme Court or the High Court to decide whether it should be disclosed to the public or not. But then you have, reports that are given by the, centrally empowered Committee on Environmental Issues. They're not privileged. They're recommendations, they're reports. They're not privileged. They're given to everybody in advance. So there are a variety of documents, but I don't think the Supreme Court has to lay down the law because it is already there. It just has to implement the law.
All right. Thank you very much, Justice Lokur, for joining us, explaining us the sealed cover jurisprudence and why the Supreme Court must insist that affidavits must be submitted by officials in court, explaining why the report has to be in a sealed cover and only affairs pertaining to the state and the state's relations with other countries must be given in a sealed cover. On that note, we're taking a short break. Lots more on Newscenter when we are back. Welcome back. You're watching Newscenter. Let's now turn our focus on the much-awaited and much-delayed Indo-UK free trade agreement. There has now been some progress on the FTA. I caught up with Rajesh Agrawal, London's Deputy Mayor for Business. He told me that financial tech and renewable energy are among two pivotal areas where the countries were intending to collaborate on. Listen in.
I'm here with 10 very innovative, fast-growing tech companies from London. They're all willing to expand into India, tap into the huge market that India is. And equally, I'm talking to some of the Indian companies who are looking to expand globally, and I'm inviting them to do that from London, and that's why I'm here. The opportunities between the UK and India are absolutely immense. There are various areas where there can be huge amount of cooperation. There's already there are certain areas where there's a huge amount of business, financial services, but that could grow a bit more, legal services, but tech is the real prize. There's very fast-growing tech ecosystem. In London is the third largest tech ecosystem in the world, and India is a huge center for technology, a lot of activity happening around startups, scale-ups, companies. So huge opportunity for both countries to come together. As and when the FTA, the free trade agreement, is signed between the two countries, that will give a further boost to the relations between the UK and India.
Right. If we ask you about areas of interest, three key areas of interest in the Indian market from the point of view of UK companies, which would those be? Or London companies?
Well, climate tech is an obvious one. India is doing a huge amount on climate technology and is leading the charge on some of the initiatives around tackling the climate challenge, as is London and the UK. So again, that's one area. So some of the companies that have come with me are in that area, whether it's electric vehicle charging, whether it's renewable energy. That's a huge area of cooperation. Fintech, financial services, insurance, etc. That's another area. And then smart city, the urban technology. That's another area where the two countries can work together.
Now back to court action. Partial relief for NSE in the co-location case. The Supreme Court has directed market regulator SEBI to refund 300 crore rupees, which the exchange had deposited under disgorgement orders. The Apex Court also refused to stay Securities Appellate Tribunal order, which has struck down the earlier order directing the NSE to pay 625 crore rupees plus interest. Ashwin Kumar joins us now with the latest.
Well, relief coming in, partial at that for the National Stock Exchange. 300 crore rupees has to now be refunded by the market regulator to the National Stock Exchange, and this after the Supreme Court's intervention, after the Supreme Court directions. Keep in mind that the issue pertains to the co-location case and SEBI's disgorgement order. SEBI had passed a disgorgement order directing for NSE to pay a sum of 625 crore rupees plus interest. It added it up to about 1,050 crore rupees. NSE coughed up that money. However, the Securities Appellate Tribunal held that SEBI's disgorgement order was illegal. Now, it is on the back of that the SEBI has moved the Apex Court. Today was the first hearing. They made their case. There was a brief exchange of arguments. However, in fact, the Apex Court did not seem impressed. In fact, the Supreme Court at one point even remarked that this case goes way back to 2012 and questioned if the market regulator was asleep at the wheel, and with that has passed the market regulator to refund an amount of 300 crore rupees. That amount goes back to the National Stock Exchange. No stay has been granted on the Securities Appellate Tribunal order, so that order continues to be in effect. So the Apex Court not coming to the aid of the market regulator, asking for that refund of 300 crores.
All right. Thank you very much, Ashmit, for joining us on that big order from the Supreme Court. Now, days after Tata Consumer Bisleri deal talks being called off, we learned that not just the valuation, but disagreement over the deal structure, limited access to data may have been some of the reasons behind talks failing. Mangalam Malu is here with the latest. Mangalam, over to you.
Well, that's correct. You know, we were just looking at Tata Consumer and Bisleri's announcement on Friday itself, the fact that the negotiations have ended. So at the same time, I was trying to find out some of the reasons. While valuation would have seemed an obvious parameter, but we understand from some of the sources in the company and ones who were working on the deal that there was a lot of delay in these negotiations. They were going on for over 8 months, and as a result of which there was some disagreement over the deal structure as well. So those were some of the factors. You know, a lot of the data points as well were the lack of access to that were some of the factors that would have led to the deal actually falling through. Valuations, while they were on the higher side, were definitely not the main concern. And remember, Tata Consumer's beverage portfolio anyway over the last few years has been growing twice the Bisleri's growth rate. In fact, Narishco reported 44% growth CAGR between FY20 and FY23, whereas Bisleri grew about 20% between FY20 and FY15 itself. The other parts of the Tata Consumer business, which is Tata Copper Plus, which is their value-added water, was growing at a CAGR of over 100%. Their premium segment, which is actually, as a market growing 2 times the normal segment, has a market share lead of 3:1 as against Bisleri's Vedika. So Bisleri would have, you know, Tata Consumer would have grown to Bisleri's size in a few years organically anyway. But what the deal would have given them is immediate access to the market and infrastructure. Bisleri had about 120 operational plants, a distribution network of 6,000 plus touch points at the same time, 7,500 trucks too. But now Tata's will go ahead and build their business organically for the beverage business. So that's what we've found out from our sources.
And aviation consultancy firm Kappa expects airlines to post $1.6 to $1.8 billion worth of losses in the next fiscal. This even as domestic and international traffic is expected to grow by more than 20% year on year. Aviation Minister Jyotiraditya Scindia, Air India CEO Campbell Wilson, along with other CEOs, attended Kappa India's Aviation Summit, while the minister emphasized on the need for India to look at manufacturing aerospace products. Airline CEOs shared their view on the sector, the opportunities and the challenges. CNBC-TV18's Madiha Mujawar and Danish Anand get us all the action from the summit.
The who's who of Indian aviation have gathered here in Delhi for CAPA India's Aviation Summit. This is the first time after 2019 that CAPA has organized this summit. Air India CEO Campbell Wilson was the first one to speak at the event. He said that the airline is temporarily reducing frequency of some of its flights to the US destinations due to shortage of crew. Ajay Singh of SpiceJet told CNBC-TV18 that the airline is considering converting more of its dues into equity to reduce its debt. Meanwhile, Aditya Ghosh of Akasa Air also spoke to CNBC-TV18. He said he expects aviation traffic to grow by 7 to 10% in the next few years. He also said that India will need about 500,000 new aviation professionals in the next 10 years. We also spoke to Vinod Kannan of Vistara on Vistara's merger with Air India. He said that the employees might see some designation changes after the merger, but he also added that these employees will also get opportunities, newer opportunities, and will get to be a part of an airline that is 3 times bigger in scale.
I think our largest lessor was Carlyle, and with them we have converted their debt, almost their entire debt, into equity, and so that's positive, and we will look to do the same thing with our other lessors, and that will significantly strengthen the balance sheet.
And if we cast our eyes forward maybe 12 to 15 months, we will have the first of our 470 new aircraft already in service. We will, in the next couple of months, have restored all of our grounded wide bodies to service. We will be starting to see the retrofitted wide bodies enter service. So I think in the context of global aviation, the pace of this transformation will be, if not unprecedented, will be close to it.
I think the most efficient operating structure is to have one full-service airline and one low-cost airline, and I think that's what is the construct we are working towards. But the good work that's being done by Vistara and everything that we've built, I think everyone, including the shareholders and the people at Air India, value what we brought to the table. So we will want to make sure that that continues, and the transition, if at all it happens, is done to a better product, if not the same.
The Indian aviation sector is all set to reach new skies as more and more airlines are slated to place more and more new airplane orders. Akasa Air, which placed an order of 72 aircraft in the beginning, is all set to place another big order of more narrow-body aircraft by the end of this year, as the airline feels that narrow-body is an important element for the airline strategy and a good future ahead.
You can and should expect Akasa to place a much larger order before the end of this calendar year.
And sir, what will be your focus as far as narrow-body and wide-body aircraft is concerned? When can we expect Akasa to focus more on wide-body aircraft?
At this point in time, we're focused on narrow-body. So as I talked about this significantly larger order by the end of this year, you should expect it to be a narrow-body order, not a wide-body order or a turboprop order.
I think outlook is very robust over the next several years. I think, we're looking at something like a 7% to 10% annual growth over the next 5 to 7 years. So, and like you said, traffic is back to what it was pre-COVID, but now it's time to kind of look ahead, and say, okay, we learned from COVID, but going forward, I think, yeah, at least I look at it 7 to 10% annually over the next 5 to 7 years.
All right, that was Danish and Madhya with a status check of the Indian aviation sector. With that, it's a wrap on this edition of Newscenter. Thank you for watching. Stay tuned to CNBC-TV18. News continues on the other side.
When our big boss was MD, he used to take